The term that the lively people use in these motions is ephemeral messaging, which I actually think is not helpful to them. I would have put like self-destructing messages or something. I don't know. Ephemeral to me is like, yeah, some things are around for a long time and some things are not. Can you destroy something that was never really there in the first place? We made it to episode 3. I made it to episode 3. I'm pretty impressed with myself. I'm getting more used to talking in a way that I know some of the people listening can't see me. I'm just not used to that. But then I also remember, some people can see me. So I'm sort of getting used to the balance of, how I hold myself, how I talk, how I move my body, all those kinds of things. I am recording this while we are deep into the winter break. We have reached the point of the break where everyone in my house is getting real tired of each other. We're bickering at each other about the smallest little things. It's really good for us to go into our separate corners. I don't know if other people experience that, but I have a very small family. It's just me, my husband, and my son. And we get along really well, 95% of the time. We like to do the same things. We like to go to the same places, all that stuff. But the 5% where we are on each other's nerves, we literally shouldn't be in the same room together. We just poke and pick at each other. And that is where we have gotten to after a handful of days, all home in the same house with really not all that much to do. So I'm looking forward to maybe getting some routine back next week, even if there's not school or necessarily even work. Just having some time for ourselves, I think, is good for any family, right? I am fighting this urge because I'm home and I don't have my day-to-day job. I feel like I should be productive, and my brain knows that is just me saying, no, you shouldn't rest because that's lazy. And my brain knows it's not true, right? But I still will walk by a cabinet and be like, I should really clean that cabinet out. And I'm one of those folks who, if I see something and it's just untenably messy, I can't stop thinking about it until I've fixed it. I'm not that way with everything. Not everything has to be perfect. But the other day I opened up a drawer, and it's not a drawer I typically look in. And it was like a bomb went off in there. And I was just like, oh my God, I can't deal with this right now. But I'm going to have to clean this, make a mental note. I'm going to clean this thing out later. And for the rest of the day, I just could not stop thinking about that drawer. I could not relax knowing that it was in my house. And so by the time we got done with dinner, I was over in that drawer with a garbage bag, throwing out half the stuff in it. And I'm trying not to spend my whole break doing that. But this is a fight every single time. But I have had some good lazy couch time because that's probably what my body and my brain needs most of all, So thanks for sticking with me. I've got these first 3 episodes, and I know 2 of them are Lively Baldoni, and that doesn't mean that this is a Lively Baldoni podcast by any stretch. In fact, after this episode, the next episode is most likely going to be about other things. But because we have this hearing coming up on January the 22nd, and because it is a very, very big deal, I feel it's my responsibility to make sure that everybody is prepped for that to the extent they need to be, and is certainly prepped for whatever coverage it's going to get, to know what's actually happening in the hearing, because it's late December as I'm recording this, and I'm already seeing people try to spin what this hearing is about and what it means. So today I am going to give you the overview of what's going to be argued at that hearing. I'm not going to get super deep into the arguments because that would take me hours and hours and hours. If you want to look at every single argument that's been made and what the responses are, I have a spreadsheet that I started working on when the motions were originally filed. I have now filled it out to include the responses to those motions from the Lively side. That document is on my Patreon. It is free. You don't have to pay me anything to get it. But if you want to sit there with a document while you're listening, if we get a chance to listen, or otherwise just want kind of the bigger picture, go over to Patreon and look at that document. This is going to be a general overview on each of the topics that are going to be discussed in the hearing. And I've organized them not in terms of the motions, but in terms of sort of subject matter buckets, because I think it's easier to understand that as an overview. It's easier to say like, well, there's an issue about this, and here's all the way that's coming out. And there's an issue about this, because I think that helps not only it make a little bit more sense without getting brain fatigue, but also it helps to really highlight what the potential outcomes in the case are and how they could have implications for cases beyond this one. So there are already stories out there on the internet from self-proclaimed media organizations saying that Baldoni and the Wayfarer parties are trying to deny Lively her right to go to trial. And that's actually true. The motions they have filed are called dispositive motions, and they are motions that a defendant can file to say this thing doesn't need to go to trial. So it's true in a way. He is trying to deny her the right to go to trial, because that's what these motions ask the court to do, to throw the case out based on law. What those articles don't say, of course, is that this is an incredibly common motion that is filed in civil cases. In employment cases, the defense files a summary judgment motion at least, I don't know what the exact numbers are, but I'm going to guess it's far more than 50% of the time. I'm trying to think if I remember a case I've ever dealt with where somebody didn't at least try. So they are very common motions. That doesn't mean that they are commonly granted, but they are very common mechanisms that defendants use, because it's really your last opportunity to say, Your Honor, we've gone through all of the procedures, we've gone through discovery, we have all the evidence. There's just not enough here for this thing to go to trial. A trial would be a waste of everybody's time. And that is the type of motion that has been filed by Wayfarer. There's also a motion that's been filed by Lively that's going to be discussed at this hearing, and I'll talk about that at the end. So in terms of having oral arguments at all, this is very uncommon. Most federal court motions are decided on the papers only. Now, the parties, when you file a motion or you have an issue with the court, you can file a formal request for oral argument. No one did that here. The judge decided to have oral argument on his own. And I think that means two things. One, he has questions, because what happens at oral argument is the judge is like, okay, well, I read this, but what about this? I have a question about this. I don't understand what you meant here. And two, that the judge realizes that no matter what he does here, no matter how this case ends up, somebody probably is going to appeal that decision at some point. If he were to grant the motions, Lively would appeal them immediately, because that would end her case. And if he were to deny the motions, then that might be a basis for appeal for Wayfarer down the line. So he realizes there are very big implications of this, and he realizes that everybody is watching. It's a gift to us, even if we don't get to hear it live, even if we have to read a transcript, because the best thing about oral argument as a lawyer or somebody who cares about the issues in the case is that you can tell what the judge is caring about by the way he asks the questions. That doesn't mean you know what he thinks. Some judges sort of reveal themselves in oral argument. If you've ever listened to an argument from the Supreme Court of the United States, they have those on audio, usually on their oral argument days. Some justices and some judges are very like, hey, I'm just going to tell you, I'm leaning this way. What do you think? Am I missing anything? And some judges are a little bit more careful, and they don't sort of reveal if they have any preconceived notions about the issues. But simply by virtue of listening to the questions that they ask, you can oftentimes figure out like what's percolating in their brain. So I think it's a gift, whether we get to hear it in real time or whether we get to read a transcript a couple of weeks later. It is hard to know logistically how they're going to do this, because you have multiple motions. And when you have multiple motions at an oral argument, that makes it complicated. So typically at a hearing, a motion is queued up for hearing. A motion is literally a party moves the court to do something. We hereby move the court to enter a judgment for this. We hereby move the court to enter an order doing this. And because of due process, if you have a motion, then the other party gets to respond and say, here's why you shouldn't do what they're asking. And then the party initiating it gets to reply. And you've seen that in the paperwork so far. And that's usually how the hearing goes, is whoever's motion it is gets to go first, and then the opposing party, and then they come back. Now, sometimes it's not that way. Sometimes the judge will say, I don't need to hear the moving part. I've read your motion. I get where you're coming from. I just want to hear what the defense is. And sometimes it jumps all over the place because you have a judge who just has a million questions and they ask them out of order. You have to be prepared for however they're going to do it. I don't know how Judge Lyman is going to handle this. I don't know if he's going to have all of the, especially the MJOP and the MSJ, the motion for judgment on the pleadings and the motion for summary judgment, argued at the same time because they are similar. They have a lot of similar themes and a lot of similar grounds in them. Whereas the motion for sanctions regarding the spoilation of evidence is kind of off on its own. So I'm guessing that's going to have its own argument. Another thing we don't know is who's going to argue what. So when you have multiple motions, sometimes different lawyers handle different motions, right? So let's say it could be that Gottlieb argues the motion for judgment on the pleadings and Ezra argues the motion for summary judgment. Right. So we have no idea how this thing is going to go, and we're not going to know until either we get there or we see what happened, because judges have total discretion over how they want to do this. They can do it however they want, as long as they give everybody equal opportunity. So quickly, a reminder of, again, taking that sanctions spoilation of evidence motion to the side for a minute. Looking at the motion for judgment on the pleadings and the motion for summary judgment. Those are called dispositive motions. And they're called dispositive motions because they can dispose of the case. They are asking the judge, you don't have to get to a jury, to a fact finder in this case. The law takes care of this case all by itself. And therefore, we are asking you to make the legal determination that there is no way that the plaintiff can win. And therefore, there is no need to let her try. And it's hard to sort of put into lay terms, what that means to a judge. But this is the only way I can think about it that's kind of helpful, is they're kind of saying to the judge, if we were to let this thing go to a jury, right? If it's like, hey, let's let this all go to a jury. Let's let them hear all these facts and let them untie all the knots and figure out who did what to whom and what's relevant and what's not. And they came to the conclusion that Lively should win. We would then be filing a motion to tell Your Honor, you have to set aside the verdict because the verdict is contrary to the law. So when you file a motion for summary judgment, you're kind of saying, don't go all the way down and invest all this time and court resources and human resources to go to a trial where the law is not going to allow her to win this case properly anyway. And if for some reason a jury did give her a win, you would have to undo it. So they're not so much asking the judge to say, aren't you tired and bored of this? Aren't you just sick of hearing all this? Which, I'm not going to lie, I'm sure that goes into their thinking, but they're more asking the judge, this is a case where you don't have to get into the factual decisions of what happened on this day, what video was it, who sent the email. Because based on the information we have in front of us that's undisputed, the law already tells us that she can't win. That's what these motions are asking the court to do, to enter an order and ultimately a judgment saying this case has been decided on the law. It will never be decided on the facts because it doesn't need to be, and Wayfarer wins. That's what Wayfarer is asking the court to do. I, for one, sincerely hope that Judge Lyman, especially if we get to hear it, but even if we get to read it, peppers them with questions. You may have seen this in like Supreme Court arguments or other oral arguments that you've seen around the world. Sometimes judges and justices will ask very few questions, and sometimes they'll ask a ton. And when they ask a ton, that's called a hot bench. That means you barely get, may it please the court out of your mouth. And like, well, what about this? And what about this? And can you answer this? And look at page 73, right? A hot bench is the best way to get more argument in and to get more information in, because you don't waste time with the parties trying to get out, whatever their side of the story is. Now, the people who are the best at oral argument are people who can basically just stand up there and react to questions, but then find a way to turn the end of their answer into the thing they wanted to get out anyway. That is a skill. That takes practice. But once you're able to do it, you kind of get to the point where you prefer a hot bench. Like, you prefer to just stand up there and be like, what questions do you have? Like, let me answer your questions. Because you don't want to give a prepared speech because you're going to get those talking points in anyway. So it'll be really interesting whether we hear it or read it to see how these lawyers deal with a hot bench if we have one. I've heard a couple of them arguing in hearings before. Some of them are pretty good. But I just, as someone who who's really interested in that part of practicing law, it'll just be interesting to see how these lawyers perform under those circumstances. So in terms of the motions themselves, the motion for judgment on the pleadings and the motion for summary judgment, I have taken both of them and I have put them into 8 buckets of issues. There are essentially 8 major legal issues that are going to need to be decided that are probably going to be discussed at this hearing. Each of those issues has multiple sub-issues. So again, I can't get into every little piece. If you want to look at more detail on that, I've got videos about that on my YouTube and on my TikTok where I go into greater detail about what all of these arguments are. But these are the big picture 8 legal issues that they are going to have to deal with at this hearing. That Wayfarer is going to argue one way and Lively is going to argue the other way, and the judge is going to have to decide. So bucket number 1 is, can you apply California law to incidents that happened on a movie set in New York and New Jersey to people who live in New York and do their work in New York? And you would think that would be simple, right? This is one of those things where you're like, don't lawyers know that? It is so circumstance dependent. It depends on the facts and circumstances of every single case. So generally, and this is generally it is true that only the legislature of a state, right? We have 50 states in the United States. The legislature of each state can make laws about things that happen inside that state. But they can't make laws that apply to people outside of that state unless those people outside subject themselves to that state's laws. It's kind of like personal jurisdiction. So what Wayfarer is arguing here is that the California laws that Blake Lively is suing them under, including FEHA, which is their EEO law, and some other California statutes, those laws were passed by the California legislature and signed by the California governor to apply to people who live and work and do things in the state of California. And that had there been acts that were part of the sexual harassment or part of the retaliation that occurred in California, then maybe California law would apply, but there aren't. Their argument is everything happened in New York and New Jersey. And so you can't apply California law. There is absolutely no connection between California law and what happened on the set of It Ends With Us. Lively and her husband live in New York. That's where their main residence is. That's where they pay taxes. And that's where the movie was made. Lively's response to that is essentially there's a California choice of law clause in her actor loan out agreement. So this happens very commonly. In fact, if you start looking at it, almost every contract you've ever signed has a choice of law provision in it that says, if we have a dispute about what's in this contract, we will apply the laws of X, right? And you can agree to follow law other than the ones of the state that you live in or the ones of the state that you work in, right? You can. I have never been to South Dakota, but if I signed a contract saying this contract is governed by the laws of South Dakota and we have an issue, guess what? We're applying the laws of South Dakota because I signed it of my free will in a bargained and negotiated agreement. So now I have to deal with South Dakota law. So Lively's argument is it's in the actor loan out agreement that any disputes arising out of this are going to be covered by California law. The problem with that, of course, is she didn't sign the actor loan out agreement. And there is a live issue as to whether it is even enforceable as a contract in this case. So she kind of has to do 2 things at once. She has to say, first of all, I have this actor loan out agreement and it is enforceable. And second, because it is, that's why California law applies. Now, there's always legal tension between these concepts of contract choice of law and the extraterritorial application of a state's laws, right? Because we have state sovereignty, but because we also have free will to make contracts, there's always tension there. But in this case, where the contract that she's trying to utilize is unsigned, and we are not sure whether it's enforceable or not, it becomes a little bit more complicated. I think there's also a piece of this issue to remember, just like in the motion Lively filed for sanctions after Wayfarer's case was dismissed under this California law called 47.1. She is asking a judge in New York to apply California laws. And he's a federal judge, so he has the authority to apply the law of every state in the union and also federal law. But asking a judge in New York to enter an order saying that California law applies when movies are made in New York, even if the reason for the California application is an unsigned contract, that could have implications in other cases. So you know he's going to be thinking about that. Bucket number 2 is pre-suit requirements and whether they were followed. So the Wayfarer parties are arguing that Lively's attorneys missed a step before they filed their federal court case. So for anyone to file a discrimination case, you first have to file a charge with either a federal anti-discrimination agency like the EEOC or a state anti-discrimination agency, which in California is called the CRD. And Lively did file a pre-suit CRD in California. She got a right to sue letter, which is the piece of paper that you need that says, okay, you're ready to go file your case. And then she went and filed her case in federal court. What Wayfarer has said the problem is that when she filed that charge with the agency, she filed it against the wrong corporate entity. And now it's too late to fix it. So there's Wayfarer Studios, which is its own company, right? And then apparently this is common in the movie industry. I'm just learning this. Every time there is a project, they create a separate LLC, a separate limited liability corporation. And that limited liability corporation is the production company for that film and that film only. And they do all of the work and all of the income through there. And that's probably partially for taxes and probably partially for liability protection, which is exactly what this is. So Wayfarer Studios created an entity called It Ends With Us Movie LLC. And It Ends With Us Movie LLC was actually the producer of the movie It Ends With Us. It Ends With Us LLC is the corporate entity that the unsigned actor loan out agreement is with. It's between Blakel, her company, I'll talk about that in a minute, and It Ends With Us Movie LLC. So remember, this is an employment law case. So if she was employed or otherwise retained, it was not by Wayfarer Studios. It was by It Ends With Us Movie LLC. And what Wayfarer has pointed out is that when Lively filed her agency charge before she filed her federal court case to check that box, which you have to check before you can file a case, it's called a condition precedent to filing. She did it against Wayfarer Studios and she didn't do it against It Ends With Us Movie LLC. And that by the time they figured this out and they went back to amend the CRD to add It Ends With Us Movie LLC, it was too late. Now, Lively has, of course, argued her responses. We went back and fixed it. There's two problems with that. One, we can't see it. There was some sort of amended complaint filed and some sort of letter issued from CRD, but it has been sealed for some insane reason because it's a public document. So I can't see it and see what it says. And number two, in Lively's response to these motions, when she mentioned this, she cited no law for the proposition that you can go back and add somebody later and it still counts. And I guess this probably seems petty to some people, like, oh, what's the difference? But like, if you're somebody who deals in creating companies, this makes a huge difference because Wayfarer Studios was never her employer. Even if she can make the case that she was an employee, they were never her employer. It Ends With Us Movie LLC was. And why I think it's such a brilliant argument by Wayfarer is because it sort of has a domino effect, right? If the judge says, okay, they didn't file an agency complaint, so they didn't check the box with the entity that actually matters, and It Ends With Us Movie LLC cannot be sued for employment discrimination, then no one else in the case can be sued for employment discrimination either, because nobody else employed her either. So those claims go away without even having to deal with anything else. I can't see it, which is crazy, but the fact that they are not, putting it out on the front page of their complaint leads me to believe that it can't be very good. But again, This is asking a federal judge in New York to decide how California agency law works. And he's going to want to be really careful about that. Right on the heels of that is the argument that's probably the most popular. I think people have really latched onto because it's something that people are used to talking about, which is, again, these are employment discrimination claims. Was she even employed? And there's no question that she was providing services. She was doing work as the lead actress and executive producer on It Ends With Us movie, LLC. But when it comes to the law, it matters whether you are an employee or whether you are an independent contractor in the way that you do your work. And this upsets some people. And I think I talked about this in a prior episode. And some people get very upset by it that, oh, if you're an independent contractor, that means people can just sexually harass you. No. Independent contractors are not subject to the same uneven power dynamic that employees are, because an independent contractor can just leave and never work for that person again. Or independent contractors have contracts where they can say, you're going to pay me because I need to stop working because you're harassing me. So they have mechanisms for relief, but they don't have employee and employer-based laws as one of those mechanisms. Now, under Title VII, which is the federal discrimination law that she's using for sexual harassment, this is a very cut and dry black and white issue. Federal law is very clear that Title VII does not cover independent contractors. So if she is found to be an independent contractor, she is not covered by Title VII. Full stop. FEHA, the California anti-discrimination law, does cover independent contractors up to a certain point. So that is a more complicated analysis. And I'm going to be interested to hear more about what the Lively people argue at the hearing about this. But both sides actually agree on the legal standard for determining whether she's an employee or an independent contractor, because there's really no dispute about this in the law, which is you have this thing called the control test. And whether someone is an employee or an independent contractor is based largely on how much control does the employer have over them, or how much control does the worker have. Because the more control the worker has over the time, place, manner, whatever of their work, the more likely it is that they are an independent contractor, because they're exercising that autonomy and independence that independent contractors get. And the more that they are under the employer's control, the company's control, the more likely it is that they are an employee. And both sides, frankly, have made good arguments in either direction. You know, Wayfarer says, you know, you're an actress and we don't control any, we just tell you where to go and you do your interpretation. And then, of course, Wayfarer points to all of the things that she took additional control over the film, like she did more editing than she was planning to, she did more wardrobe than she was planning to, she got that producer credit. So they make the argument that how can she possibly have not been in control when over the course of the film, she gained more control, more autonomy over things that were going on in the film by her own admission to the Producers Guild of America. The Lively argument back is, you told me where to go. You told me what to wear. You told me what to say. You told me when to show up. You told me when I can have breaks, right? So she is addressing those sort of like more day-to-day control issues. And she points to things like, well, I was under your workers' compensation policy, right? And that matters and it doesn't. But I think the hardest thing for Lively is that Lively does her work, and I think this is common for actors. Lively has a company called Blakell Inc., which is, you know, Blake L. Inc. And it's a New York company. And that is a company that she is an employee of. And that company then loans Blake Lively, the individual, out to production companies to make films and TV, presumably. And again, the reason you set a structure up like that is for tax reasons and for liability reasons. So she is an employee of Blakell Inc. So I think it's a pretty hard argument to overcome of how can you be an employee of It Ends With Us movie LLC if you're already an employee of Blakell Inc. So I'm really interested to hear what they're going to say about that. But if the judge were to find she is an independent contractor, her Title VII one of her sexual harassment and one of her retaliation claims are off the table. Then you just have to deal with the California law that is left. Bucket 4 is sort of a more traditional summary judgment argument, which is one of the elements of your claim you don't have any evidence for. And so that's sort of it's sort of like a house of cards. Without that element, you have no claim. So to remind you, the elements of sexual harassment are unwelcome conduct based on sex, severe or pervasive to the person it happened to, severe or pervasive to a reasonable person under the same circumstances that altered the terms and conditions of that person's employment. And so what a defense does is says if any one of those things is missing, the whole thing goes away. Because in order for this to proceed to a jury, they have to have evidence where they're capable of proving each and every element. So Wayfarer makes a couple of arguments saying she's missing elements of their claims. Now, I'm going to say straight up, these are their weakest arguments. These are Wayfarer's weakest arguments, and these are Lively's best arguments. Because the elements of what makes up a claim like sexual harassment or retaliation involves a lot of facts. And if there are facts in both directions and it could potentially go either way, that is an issue for a jury. So Wayfarer has argued that severe or pervasive, she can't prove severe or pervasive because the only evidence we have of the things she claims constitute sexual harassment are under the law just not bad enough to rise to the level of sexual harassment, to rise to the level of severe or pervasive. They say a similar thing with the because of sex, right? A lot of the things she's claiming constituted the sexual harassment has to be because she was a woman. But these things also happen to men. And therefore, they cannot, by definition, be because of sex. The hugging, showing of the birthing video, talking about their past sexual experiences, all that kind of stuff. Now, again, these are decent arguments, but a judge does not want to, if he does not have to, issue an order that says, sorry, but what happened to you just wasn't that bad. Now, they do it. And if something falls below the threshold for legal responsibility, then that's what a judge has to do. But I think part of the reason that we're seeing all of these options that have been laid on the table for this judge is because Wayfarer knows that issue, number one, is generally a fact issue under the law the vast majority of the time. And number two, it's just a little bit difficult to, not difficult, but you don't want to call somebody, you don't want to say to a really high profile woman in a really high profile case, get over it, what's the big deal? But they made the arguments anyway, and so they're there and the judge can look at them. For the retaliation, this I think is a much stronger argument for Wayfarer. For the retaliation, remember there's only three elements there. There's protected activity, adverse employment action, and a connection between the two. You just have to prove that one caused the other. And they make the argument for the retaliation claim that she cannot prove the adverse action because whatever it is she says happened to her, where her reputation took a hit and Blake Brown didn't sell and blah, 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 she was not employed when those things happened. That had nothing to do with her employment. So how can that be an adverse employment action under an employment law? Her team has admitted in the past that they are asking the judge to extend retaliation to cover reputational damage in a way it's never done before. They admit that. They admit that they are asking the judge to stretch the law, which I think is candid because they definitely are. But the way that they responded to this in their written papers was not terribly compelling. They just sort of said, well, sometimes people are in an industry where it matters if you're wholesome, which don't even get me started about actors being wholesome. But I think they may feel like maybe this one's a lost cause. Maybe it's not worth arguing because asking a judge to extend the law further than anyone ever has, and this is a judge in the Southern District of New York. He deals with famous people and their disputes all the time. I think that he's going to be really reluctant to do that. But there are also other arguments with regard to an element missing. And the last ones Wayfarer make are on that causation, right? You have to prove that the protected activity caused the adverse action. So what they're saying is, even if the judge found, you know what, it's enough, we're going to let it go to a jury can decide whether that was really adverse to her and it really was part of her employment. But you still have to prove that one caused the other. What Wayfarer does is they argue the link was broken multiple times. The link between the protected activity and the adverse action. And it was broken, first of all, by the fact that there was so much time between the two. There's an argument over when did she engage in protected activity? Was it in May 2023 when she first brought these issues up? Was it in November 2023 when they signed the 17-point agreement? Was it in January of 2024 when Reynolds yelled at everybody at the meeting at the house, right? But regardless of when you make that time, there are months and months and months between that and the alleged smear campaign. So Wayfarer argues a link is missing there. That is a hard argument to make because, again, I think a jury could take that and say, you know, just let the jury look at all the facts and they'll figure out whether they think it's connected or not. They also say it was caused by two other things. It was not caused because of the protected activity. It was caused because we were protecting ourselves from bad press that you had started. So there were intervening events. The two things are not connected. Yes, they both happened with the same parties, but one didn't cause the other. And again, I think that's a harder argument to make because that is where fact issues come in. That is a place where a judge would probably say, well, let a jury sort that out. So I don't think those are the strongest arguments for Wayfarer. Bucket 5 is what I call the contract rock and a hard place arguments. From the very beginning of this case, people clocked, non-lawyers clocked, that Lively was suing for breach of her actor loan out agreement, but she didn't attach it to her complaint. She didn't attach it to the amended complaint, and she didn't attach it to the second amended complaint. We didn't get to see it until a couple of months ago when it popped up attached to something as part of a discovery dispute. And as soon as we saw it, we knew why. Because the thing isn't signed, which is what had sort of been the rumor all along. And as I said earlier, Lively really needs that actor loan out agreement to be enforceable because without it, she cannot apply California law. That is the only California law nexus in this case. And so she really needs it to be enforceable. So Wayfarer says, okay, bet, we can talk about that. We can talk about why it's not enforceable and we shouldn't go there. But even if we do, it's not as great for you as you think. So Wayfarer first makes the arguments we all knew they would, which is this thing isn't enforceable because she didn't sign it. And therefore, because she didn't sign it, it ends with us movie LLC didn't sign it. And this document means absolutely nothing. There are arguments from her that are called course of conduct, which is, but we all acted like the agreement was in place. We all conducted ourselves as if I had signed it. And therefore, it's as if I did. And sometimes that can work. But I think the problem for her here is that there are emails and things, I think as late as early 2024, when this movie was half over, showing that they were still negotiating terms. So if you're still negotiating it, it's not course of conduct because everybody hasn't agreed. But where this really became interesting and clever by Wayfarer is where they created the other side of the problem for her, where they really put her, again, between a rock and a hard place and said, all right, we don't think this thing is enforceable. But even if it is, you've got a major problem because the terms of that document that you say you want enforced cut against your claims in this case. The first way is that, like many contracts, it has a notice and cure provision in it. So think about like your mortgage, right? If you don't make your mortgage payments, there is a notice and cure provision in your mortgage and your loan agreement with your bank. And it says that before they can foreclose on your house, if you don't pay your payments, they have to send you a notice and give you an opportunity to cure. So they have to send you a letter and say, hey, you haven't paid your mortgage in 5 months. You owe us a total of X dollars. Pay us the X dollars within the next 30 days, or we're going to foreclose on your house. That is a boilerplate in a lot of contracts, and it was in this one. It said if either of the parties think that the contract has been breached, which is what Lively claims happened by her being sexually harassed, then you have to give notice and an opportunity to cure. And Wayfarer is like, okay, if that contract's enforceable, then so is that notice and cure provision. And you never did that. You never notified us that there was a breach and gave us an opportunity to cure. And by the way, if the whole telling us what was going on in November of 2023 in that 17-point list, if that was the notice and cure, if it was like, hey, we've got all these problems and we need to fix them, we cured it. And if you cure it, then there's no breach. If you go and you get the mail and you say, oh my God, we haven't been making the mortgage payments, and you turn over all of the money right then and there, you haven't breached the mortgage. Then they say, okay, if the notice and cure, and this is essentially what Lively's people are arguing, if the notice and cure was the demand letter that Michael Gottlieb sent right before they filed the federal court case, Michael Gottlieb sent, and I think Ezra Hudson sent a demand letter to the Wayfarer people, to Brian Friedman, right before they sued, which people often do, saying, hey, guess what? We're going to sue you. Keep all your records. Don't throw anything away. Call the insurance companies. You're about to get sued. If that was the notice, they didn't give them sufficient time to cure because they filed the case 3 days later. And anyway, they sent it to the wrong company. The demand letter went to Wayfarer Studios. It never went to It Ends With Us movie, LLC. So this again gives the judge multiple pathways. He can go down any of these rabbit holes he wants. He can go down the enforceability rabbit hole and say, I'm not dealing with any of this contract stuff. This contract is not enforceable. No one ever signed it. Or he can take these sort of mini sub pathways, as many as he would like. They have teed up a whole bunch of issues for him. Now, the question of this contract's enforceability and then the enforceability of the rider to the contract, which is the 17-point list, that is such a heady and meaty and wonky issue that it would bore the shit out of you if I talked about it right now, I promise. I'm going to try to make a video where I talk about only those issues, and I would probably put it on Patreon because only the people who really care about it want to see it. But they have made multiple arguments, and Lively has responded with multiple arguments. So it is possible that a lot of this hearing could be taken up with arguments about contract enforceability and consideration and assent and note and all kinds of stuff. So prepare yourself for that. Then the last thing that Wayfarer does when it comes to the contract rock in a hard place, and this is where I think they really hit a nerve. They said, okay, if you want to have the actor loan out agreement be enforceable, we're going to enforce the whole thing, including another standard provision in that contract that says if we do have a breach, and if somebody does sue somebody else for damages they sustained as a result of the breach of this contract, those damages can only be actual damages. Nothing indirect, nothing special, nothing punitive. And that is a very, again, boilerplate term to have in a contract to say, if we have an agreement and I don't do my part, I'll be legally responsible for the actual losses that you have incurred by virtue of me not doing what I was supposed to do, right? I will pay the bank back the mortgage payments that I was supposed to pay and the interest that they would have gotten, because that is their actual loss. They expected that amount of money to come in and it didn't come in. And so those are their actual damages. But I'm not going to pay for every single little thing that flowed from that, like Bob didn't get his bonus last year because that was his account. And when the mortgage payments were late, that hurt Bob's numbers. I'm not paying for Bob's bonus because that is not actual. That is indirect. Those are special damages that are way far removed from my responsibility. And so if Lively wants to use that contract, what Wayfarer is saying is we are going to then go, the next thing we're going to do is we're going to file a pretrial motion that says you can't have any of the damages for loss of reputation or problems with Blake Brown or problems with Betty Buzz, because those are all indirect special damages and the contract says you can't do that. So they put her in this really difficult spot where if she wants to enforce that contract, which she has to, then all these other problems are going to arise as well. And on that same issue, bucket 6 is just damages generally. I think people probably don't realize most of the time that actual injury, actual damage that you can prove is an element of every single civil claim. You cannot file a civil claim if you have not been injured. And they're saying, again, she cannot prove her damages, particularly for the retaliation for the smear campaign, because all of the damages that she is trying to utilize are these indirect, special, lost profits, speculative stuff that this contract does not allow. And I have seen it happen where people have filed a motion for summary judgment, a dispositive motion, and the only argument they make is, you don't have any damages. And when the judge grants that motion and says, you don't have any damages, therefore you don't have a civil claim, they enter a judgment and say this case is over. So that alone can be a basis for summary judgment. So bucket 7 is a claim that is related to the employment discrimination claims. It's called failure to investigate. It is under FEHA, the California EEO law. And failure to investigate, it's like a regulatory compliance kind of thing, because we have these laws that prohibit discrimination. But then over time, it became apparent that we also need to require employers, also you can't just ignore it if somebody says it to you. Right? You have to actually look into it if somebody says, I think I'm being sexually harassed. That's its own sort of legal requirement, that you look into it. Not just that you don't discriminate yourself, but that you do something when someone says it's happening to them. And Wayfarer says, look, we did anything that we could have done here. We had a sexual harassment training before the filming started. People knew who to go to. They know who to tell if they were having a problem. The issue that they have is, number one, there's no record of any of this. There's no record of the training, really. There's like a PowerPoint, but there's no record of who was in the room, right? Usually you sign these things so you can say, I was there. There's no record of that. The other problem is the people that were told, this is who you go to if you have a discrimination problem, were Jamie and Justin. And so it's pretty easy for Lively to say, so I'm supposed to go to you with my problems about you, which is exactly what she did. But you can see how that's not the greatest plan. The better argument they have is that they say, when you raised these things, when you raised your issues and we got the 17-point list, your lawyer specifically emailed to us, we will agree to this in lieu of a HR process. In other words, if you sign this document, we won't need you to investigate. So how can you come back now and say that we needed to have investigated? You waived it, which I think is a better argument. Lively largely did not respond to this argument and her responses to the dispositive motions. I don't think she cares about this claim very much, because this claim doesn't really carry any money with it. It's not like a big headline or anything oh, they didn't investigate. I just don't think that it's really worth her time, which is probably why she didn't really respond to it. So we'll see how much gets argued. And then the last thing is this sort of general bucket of everything else. There are claims for false light, right? Putting her in a false light. That's that's the only claim, I think, against Sarowitz, pulling him into the case. That one's basically just whatever the judge decides on whether California law applies or not. There's again an argument by Wayfarer that California law doesn't apply. And this law in particular only applies to California citizens, even if it does apply outside of California for outside of California acts. And Sarowitz lives in Illinois. So I don't know that claim is really going anywhere. There is this defamation claim that's been out there for a while. I don't know why Wayfarer didn't try to get rid of this sooner. This is the claim that says that public statements made by Brian Friedman as Wayfarer's representative were defamatory, and therefore Wayfarer, the client, should be held liable for that. And there are multiple legal arguments in both dispositive motions about why this should not be the case. Things like the litigation privilege, which is that you can say pretty much whatever you would like during litigation. The fair report privilege, he's talking about an ongoing legal case. These are not facts. These are his opinions. There's no actual malice, because when he says Blake Lively is lying, he believes that that is true. I think that really this is just an issue of the judge knowing the implications of him allowing a claim against a lawyer to go to a jury for defamation based on a lawyer's comments during an active piece of litigation. Now, it would also have the effect of keeping Friedman from being a lawyer trying the case, which I'm sure the Lively people would love. I frankly think maybe that ought to be the case anyway. But maybe I've been shocked before, but the implications for lawyers in general here, with all of the freedom that we get to go out in public and talk about our client's case and even talk about our opponents in our client's case, I just have a hard time believing that's going anywhere. And then lastly, we're going to hear about this motion for sanctions based on evidence spoliation. Now, there are so many motions for sanctions filed by the Lively people in this case, it's hard to keep track. But this one is one of the big ones. And this is a motion that the Lively people have filed to try to explain the gaps in their proof when it comes to the smear campaign. And specifically, how the smear campaign was carried out, what the communications were between the parties and between third parties. They admit in this motion that they have not found that stuff. They have not found smoking guns where they've got, Jen Abel emailing random YouTubers saying, tell them Blake did this, tell them Blake is this, pull up that old video, right? And so Lively says the reason we don't have those is because they disappeared. Because sometime in late 2023 and all the way through December 2024, when they got that demand letter from Gottlieb telling them not to delete anything, these people were using, as one of their communication mechanisms, they were using the app Signal. And Signal, like Snapchat, erases messages automatically after a certain amount of time. And that had they not used Signal, and had they not had auto erase on Signal, they believe this would have been evidence that would have proven their participation in the smear campaign and how it worked. So the reason this is being argued at this hearing is because this is part of Lively's response to the dispositive motions. Part of what she's saying is, don't take this case from a jury simply because there is evidence that is missing, because a piece of the puzzle is missing. Because we can explain why that piece of the puzzle is missing. And if we put it in front of a jury, you will tell the jury, you've got a piece of the puzzle missing because these people destroyed that piece. That is exactly what just happened in the Megan Thee Stallion defamation case from November of 2025 into December, I think, where she was victorious. And part of the reason she was victorious is because the person she was suing after the case was filed deleted half the contents of her phone with all the evidence on it. And so Megan's lawyers were able to file a motion for sanctions for spoilation just like this and say, you can't do that. And they won, which means that Megan's lawyer and the judge got to get up in front of that jury and say, if you're wondering why there isn't a message for this or a message for that, we can tell you as a matter of law, that is because she destroyed it. And you can make the inference that the reason she destroyed it is because it would have been bad for her. And it would have proven what we say it would have proven. Lively is trying to get the judge to do the same thing for her. Lively has to do two things to be successful in this motion. There's two elements. One is that you had a duty to preserve the documents in the first place. And number two is that they weren't preserved, they were destroyed, and that they have prejudiced Lively by not being around. And just as a quick recap, we don't all have a general duty to preserve documents in case there's litigation. Like, not everything has to be maintained all of the time. You have to have some indication that litigation might be imminent or might be coming up for you to preserve documents that are going to be related to that litigation. So I think a lot of this argument is going to fall into the first element, which is, when was Wayfarer supposed to be on notice that litigation might be coming? Now, so far, they have argued they should have known that when they signed the rider of the 17-point document because they knew that she was mad. Except that the very nature of the 17-point document is that they had resolved it. So why would they think litigation was coming? But she's got a couple of different places where she says, well, they should have known at least here, or maybe at least here, or maybe at least here. So it'll be interesting to hear them argue that. So if they establish that, and only if they establish that, then you move on to the next element, which is, were these messages actually destroyed? And it's not like in the Megan Thee Stallion case where like she literally went and deleted WhatsApp off of her phone. And you have the little thing that pops up that says, are you aware that by deleting this app, you're deleting all the information? She went, yep. It's not that, right? It's that they were using an app that auto erases messages. And so there's been a lot of really interesting conversation online. And I've heard from a lot of data and tech people. I find it just fascinating that like, Can you destroy something that was never really there in the first place? Because it was, the term that the lively people use in these motions is ephemeral messaging, which I actually think is not helpful to them. I would have put like self-destructing messages or something. I don't know. Ephemeral to me is like, yeah, some things are around for a long time and some things are not. I don't think it's great terminology for them. But, we have these things on the market. Does just using them mean that you're destroying evidence? I think the best argument that people have made that I totally agree with is, what's the difference between this and saying, call me, let's talk about this over the phone, or meet me at Starbucks and we'll talk about it there where nobody can read it. As someone who's been practicing law for the better part of 3 decades, we do that all the time. We say, don't put that in writing. I'll call you later. Or, hey, let's meet up and let's talk about that, right? Because you don't want the record. So I think one of the hard questions that Lively's folks are going to have to answer is, how is this any different? Like, so what if they decided to conspire on the phone? If they conspired on the phone or they conspired in person instead of conspiring on Signal, you wouldn't have those either, right? So why does that mean they were destroyed? Obviously, there are huge market implications for Signal if a federal judge were to find that simply using their product was the destruction of evidence. And I'm sure it is not lost on most people inside the United States that our federal government is known to use Signal. So I think that this is a really uphill battle for the Lively people, but I understand why they're doing it, because it gives them an opportunity to say, if Your Honor feels like we're missing information, this is why it's missing. So those are the arguments for January 22nd. Like I said before, I have no idea what order they'll go in, how it will be done, what kind of questions Lyman will ask. I will continue crossing all my fingers and toes that we get to hear it. But I'm anticipating an argument, or maybe not even an argument, just a viewpoint from folks, because I know how the media likes to oversimplify these things, to talk about how these motions, especially if any of them are granted, are a technicality, right? The way that people will say, well, that person's criminal prosecution was dismissed because the cops violated their civil rights, that is a technicality. And the way I understand technicality in sort of the non-legal sense is when it's a process issue and not a substantive issue. And if the judge were to grant any part of either the motion for judgment on the pleadings or the motion for summary judgment, it would largely be procedural. On the summary judgment, there would be some argument of the facts, but there would be no factual findings. There would be no determination that this is what happened. This is what happened on this day. This is what these people did. This is the story that is more credible, because only a jury can do that. So, if Wayfarer has its best day on these motions, then it does give Lively the ability to say they won this case on a technicality. And clearly, Wayfarer has decided that that is worth the risk, because they know that. The best case scenario for Lively is that these motions get denied and everything gets kicked to trial, and the judge says, okay, you guys are going to trial, so you're either going to settle this thing and work it out amongst yourselves, or we're going to have a big, nasty trial. The best case scenario for Wayfarer, obviously you want to win every motion that you file, so I'm sure they want everything to be granted. But I think just as good for them could be that they get a judgment on the pleadings and or summary judgment just on the sexual harassment and the retaliation claims. Because those are the only ones they really care about, right? Those are the only ones that Lively really cares about. I don't think she's going to go to trial on a breach of contract claim. It's possible. It's possible. I don't think she's going to go to trial on a false light claim, although it's possible. So the judge has all the options in the world. He can pick and choose from this menu as much as he wants. He can be like, I like this argument from this motion and this argument from this motion, and yes to that, but no to that. He can cobble together whatever he wants to out of all of this. They have given him lots of options. And I think it's worth noting that, I can't remember if I said this earlier in this podcast, but one of the people who works at Bach and Shapiro's firm, the people who were added on several months ago, used to clerk for Lyman, used to work in his chambers. And if you don't know, judicial clerkships are usually for newerly graduated law students or really, really talented young lawyers. They are very hard positions to get, and they're very prestigious. And one of the people at that firm was Lyman's clerk. And so presumably that person has some insight into how he operates. And I think that they have given him a whole bunch of options here. My opinion doesn't really matter. And because I'm not the judge, and, people have asked me, like, who do you think has the better case? And I'm like, I can't tell you because all the evidence is still sealed. I can't, until I can see everything, I can't tell you what I think the best, who has the best argument. Maybe before we get to this hearing, I'll have a chance to do that because I've been waiting for that for a year. But I will tell you that I think if the judge wanted to find the cleanest way to end this case without having to get into arbitrating whether conduct was bad enough to be sexual harassment or whether there is enough evidence of a conspiracy to smear a famous actress. If he wanted to end the case without having to reach those issues and weigh in on that and risk, backlash against him or, something like that, he has a very clear pathway to do that through the actor loan-out agreement. The cleanest way for him is to say, these were very sophisticated parties. They knew what they were doing. Lively made a choice at the beginning of all of this and over again during the course of the movie not to sign the contract. That was her choice. She was represented by lawyers and business people. She knew what she was doing. And by doing that, she waived her right to have California law apply to this case. And everything could just sort of fall in line from there. That's the cleanest thing for him. I'm not sure if he'll do it. And again, there's stuff I still can't see. But they have given him multiple options so that he can put together whatever decision he feels most comfortable with, whatever he thinks is going to hold up on appeal. So cross your fingers that we get to hear that hearing or at least get a transcript really, really quickly. And I hope you'll come back next time. I'll be here because the drama never stops and someone has to make it make sense.